for that introduction, and thanks for inviting me. I actually invited myself. I said to, I don't know if she's here, we had a summer student from West, no, of course she's not here. She listened to me for an entire summer. We had a summer student, yeah, at Civil Liberties Association, and I said, yeah, you should get me to come speak at Western. And she said, I think I can swing that, and here I am. So yeah, thanks for agreeing to have me come, I guess is what I'm saying. And I have not been here in quite a while, and I saw some looks of knowing compassion and sympathy when you heard that I was an Attorney General at the age of 37. What that meant was I still had my student loan while I was the Attorney General. And the Criminal Lawyers Association, they were not thrilled to hear that because you kind of get what you pay for, right? And so they threatened to pass the hat, but they never did. And the perspective I have on the bail system that I'm going to share with you today is taken from the time that I was the attorney for 4 years. For 4 years before that, I was the Attorney General critic, so I got to be in opposition on the other side before we went into government. And then afterwards, I mean, once you get that job, I mean, it's hard not to stay engaged in the system. And I then had a series of experiences, the most obviously helpful of which was that I started practicing criminal defense law at a level that usually a former Attorney General would not engage in, right? I'm sure that there have been attorneys general who have been duty counsel, but they were duty counsel in their 20s, not their 50s. How I ended up there is a long story, which is on a TED Talk Toronto, that comes up in the next couple of weeks, and it's a good story. But forget about that. I'm going to talk in part about that experience of having served as duty counsel, managing, say, 40 bails in a day, in the interesting circumstance where I'm appearing before judges and justices of the peace that I had appointed, right? And with prosecutors who used to think of me as their boss. For clients, by the way, who could care less who I was, like honestly could care less who I was, and thought Attorney General was something in the military. And it never came up after a while. I'm going to talk about our bail system, and I'm going to make the case for getting rid of it, for getting rid of our bail system, for abolishing it. This is something that the Canadian Civil Liberties Association is beginning to embark on as a project. It's quite an ambitious project, as you can imagine, abolishing bail in Canada. But I'm serious about it. If you're interested in helping us out, please do. CCLA is small but mighty, old but nimble. There are, less than 10 lawyers at the CCLA. We are entirely reliant upon volunteers and pro bono lawyers to bring our challenges, and we bring many. CCLA is the most frequent litigant before the Supreme Court of Canada. We have been before the Supreme Court of Canada more than 200 times. The counsel that we tend to get are the best and the brightest, and sometimes they're the best and the brightest straight out of law school. Sometimes they have gray hair. But the point is that it is a collaborative approach, and as always, as is going to happen with a 54-year-old organization, which is what the CCLA is, not me, I'm close to that, but not quite, we need to engage with demographics that we just haven't before. CCLA is entering into a new and exciting phase. And as you can see from the logo there, the way to find us is ccla.org. All right, I learned a new word preparing for this. It's nosocomial. If there's someone who speaks Greek, you can correct me afterwards. The word basically refers to infections caused by the healthcare system. So you go into the hospital and you end up getting sicker than you were when you first walked in the door. Something has gone wrong in the hospital. There's a design flaw. And the design flaw is causing people who are in there to get a new illness, unrelated to their underlying illness. Bail is as close as we have in the criminal legal system to a nosocomial infection. We don't hear much about anything like that in the criminal legal system. And that should give us some pause. The education system, the healthcare system, the welfare system, social services, these large ministries and large systems within our public services are often looked at from a macro strategic level, and items are found in there that are the cause of significant backup, or in some cases they're actually doing more harm than good. And so you try and treat it, you try and fix it, and at a certain point, I submit we've tried long enough to improve and reform bail, and in fact the time is to get rid of it entirely. I realize it's a fairly radical suggestion, but I'm serious about how it could work and how it would work better. In a just society, a criminal legal system may engage in some prevention, like our healthcare system. But most of what the criminal legal system is to do is respond to crime, investigated and prosecuted, and then adjudicated by the courts, after which there is punishment through supervision by corrections, and custody, detention, jail by corrections. I'm going to give you some more background as we go through, but if that were the case, that the criminal legal system gets bigger or smaller depending on the demand for it, then we would have seen our criminal legal system shrink, actually, in the last 20 years, right? Because we know that crime has gone down significantly over the last 25 years. But at the same time as crime has gone down over the last 25 years in Canada, remand, or pre-trial detention, has gone up over 300%. So if crime is going down and the system is getting, in fact, bigger year over year, as it is, why is that? What's happening? What's going on in the system that is causing it to be overburdened, notwithstanding the fact that the demand seems to have gone down? And the short answer is that we have a design flaw in the form of the bail system. It's become something I don't think it was ever intended to be, but it's certainly become something that is unconstitutional. The crux of the design flaw is bail. The system through bail is feeding itself. I'm not suggesting a corruption in the system. I'm not saying that this is intentional and that somebody's sitting around in a room plotting out how to get the system to feed itself, to bloat budgets. But the effect is that the system is feeding itself. And I didn't really see it clearly until I was at a lunch while it was still fresh, and I could see the bail system at its worst. Because once you get in, it's like anything else. you start getting used to the way it is. And the things that don't make sense, you just say, well, this is just the way it is. And you also start thinking in a self-serving way. As it becomes less of an adrenaline rush, you start thinking about how to make the job work better for you, right? So I wasn't there yet. I wasn't in the self-serving part of my bail defense career. And the other perspective that I have that most attorneys, former, don't have is that I've been detained. I've been arrested and charged, and I've been detained. And actually had that experience, not by way of a pretrial detention, because I was released on my own recognizance from the police station, but had the experience of what it's like to lose your liberty in the Ontario justice system for as it turns out, very short period of time of 16 hours, the longest 16 hours of my life by far. That's a whole other story, and I don't mean to belittle it in any way, but it's a whole other story. But it's important because I think it's very easy for us. I mean, this is a general comment, obviously, on the academy. It's very easy in the academy to study and look upon the phenomena of a particular system at a distance, which is excellent and necessary. But it is a unique perspective to have. And in short, my experience was, notwithstanding the fact that I had appointed so many prosecutors and I had appointed so many justices of the peace and almost 100 judges, and I knew the system as well as you could know it as a former Attorney General when I was in that cell. The system still felt like, for me, like a juggernaut, like it was out to get me. It wasn't, but I thought it was. Now, I think it's a juggernaut. What's the average person going to think? What's somebody who's mentally ill going to think? What's somebody who's in active addiction going to think? Well, they're going to be very, very afraid and disoriented in those circumstances. And one of my arguments is that the way our bail system is set up, it just begs for premature, wrongful guilty pleas. People will plead guilty to get out. And I understand that feeling of wanting to just get out. And they'll do anything to get out. And so they make bad decisions, and they plead guilty, and they get out, and then deal with the consequences of having a criminal record. Anyways, the bail system is a design flaw, and the way it operates is, I would submit, insane. Not a term you normally get to use in law school, but it is insane, and I'll explain why. Reforming bail is the last thing I'll say before I go into the background. Reforming bail is proven impossible, thanks to the prevailing insanity that public fear over future crime is a legitimate constitutional justification for incapacitating innocent people in jail, alongside the guilty people serving their sentences, with the former, the innocents, outnumbering the latter, the guilty. That's insane. Jail has become a place primarily for innocent people, not guilty people. I mean, formally innocent people. It's, as Chief Justice Lennox used to say, it's not really the criminal justice system, although we call it that. There's no divine judgment being made when I say innocent. I mean, the criminal legal system has not found them guilty beyond a reasonable doubt, nor have they pled guilty. So they are presumed to be innocent. So these presumed innocent people are in the bucket, and they outnumber the people who have been convicted or who have pleaded guilty. We say, well, that's how the system works. It's, it's just, well, remand is complicated, and the problem is, well, we just need to fix this or fix that. And I'm going to make the case as to why it's impossible. And it's impossible because the courts and policymakers who are even aware of it have accepted the idea, to repeat, that it's legitimate to keep innocent people incarcerated, not because of something they did and were proven to have done, but because of something that we're afraid they're going to do. The bail court is a court of speculation. Literally, it's a court of speculation. It's a risk management court. Aside from the flight risk defendants who are detained as a result of a flight risk, which make up quite a small number of people in remand. The vast majority of the people who are in remand, which is another name for pretrial detention, another name for being in provincial or territorial jails while they're innocent awaiting trial. They haven't been granted bail yet. Most of the people who are in there either because they haven't got their hearing yet, their bail hearing, and keeps getting delayed, or they've been denied bail. And most people who are denied bail because the court finds under either the secondary or tertiary grounds under the criminal code that they ought to be detained. The secondary ground is that the person's going to commit another crime. And the tertiary ground is that to release them would offend the public's perception of the administration of justice. So we keep people in jail because you and I will think less of the criminal justice system. It's a hell of a reason to lock people up. Almost as bad as locking them up because a finding has been made that this person is going to, or likely to commit an offense. They haven't committed it, but we're keeping them in jail because we think they might. It's insane. And we got to fix it. Come on, people. Let me give you this background. So when we talk about the prison population, we're talking about University of Ottawa. I mean, literally, the University of Ottawa is about 40,000 students. That's it. It's a small population. When people imagine, oh no, if you let all these people out of jail, there's going to be crime anywhere. It's going to be Purge 5. It's going to be... and there have always been apocalyptic movies where people get released from prisons and they outnumber the people who are not in prison. They outnumber the people who are not in prison. If all of Canada, let's see if this thing works. See, there's Canada. She's like Ontario. So that if all of Canada were pennies, these are all pennies. There's a penny. The prison population would be 1 penny. It's 1/100th of 1% of Canada. 40,000 people in a country of 37 million people. It's a relatively small, if not tiny, population of people. So to imagine that a penny of people, and I'm suggesting that we're going to get rid of half of the penny and get them out because they haven't done anything, and because the risk is entirely speculative, and because even if it's accurate, they get out anyways in a very short period of time. I've already made this point that more innocent people are in jail awaiting bail or trial than criminals serving a jail sentence. 25,000 in provincial corrections, 15,000 in federal jails, or prisons rather. It has been this way for decades. It was the reverse as you would expect, if it wasn't insane. It was the reverse 50 years ago. But at some point, the remand population doubled, and then doubled again over time, 300% larger than it was just 25 years ago. How long do people stay in remand? Well, it depends on the province or the territory. In the Northwest Territories, you will be in remand for, the median number of days is 29. You'll be there for 29 days. You haven't done anything. You haven't been proven to have done anything. You haven't even had your bail hearing. You're going to be there for 29 days before it's decided either that you're not going to get bail and you're going to be put into the pretrial, detention, or you're going to be, you're going to have your hearing coming up, or you're going to be released. In BC, it's 12 days. In Ontario, it's 8 days. Now, there has been some social science and even some Supreme Court of Canada jurisprudence talking about what it's like to be in there for 8 days. There is no rehabilitation offered, nor could there be any rehabilitation offered, because you're innocent. You're not going to offer rehabilitation services to innocent people, the argument goes. So there's no rehab services. So you're not going to offer them rehab, but you're going to lock them up, even though they're innocent. They're serving alongside of the sentenced population. And it's a place riven with mental illness and addiction. And it's a place of fear. It's a place where fear dominates every moment of the day and night. I'm not going to go so far as to say that it's cruel and unusual punishment. It's not solitary confinement. But if you think, oh, what's the big deal, 8 days? I think unless you spent a day in the bucket, you don't know what it's like. Suffice it to say, this is the greatest deprivation of liberty imaginable in our country and under our Constitution, short of solitary confinement and short of electrocution, but that's in the mental health system. So it's the greatest deprivation of liberty known to the state. We're putting you in jail, we're not letting you out for 12 days, and you've not done anything. You might have done something. Police say you've done something. The prosecutor says you've done something, but you haven't had a trial. You haven't done anything. You're going to have to wait in jail for 12 days to find out if you're going to stay in there or not. In Ontario, it's 8. But here's the part, and this is the ringer to my argument. This is how long you're going to be sentenced if you are found guilty. These are the averages in Canada. So you've been found guilty, 30% of you are going to be out in less than a week. These are the criminals, right? And before you say, oh, well, maybe they should put them in there for longer. No, if you look at the offenses, the largest number of offenses, the number one crime is a bail breach. See the insanity of this? The number one crime in Canada is a bail breach. Number 2 is theft, under. 45% no violence whatsoever involved, and no serious property crime involved. 13% are violent crimes. And then the middle portion is a mix. So assault, bodily harm, there's a bruise, but no blood. Assault with a weapon, but as I found out in bail court in Bryant, the most common assault with a weapon in the busiest bail court in Canada was assault with a spatula. Somebody whacked somebody with a spatula, and they were charged with assault with a weapon. So, you've been found guilty, you do your time, you're in there for 60% of the inmates, you're in there for less than a month. For 30% of the inmates, they're in there for less than a week. 81% of all the inmates in Canada are in there for less than 6 months. If you're getting the sense that these aren't the most dangerous people in the world, you are 100% correct. We're spending billions and billions of dollars to keep people in remand. And we're also spending billions to punish people for a month or 6 months. Max. But for most, this is all about putting people in the bucket for a month. And here's where the insanity lies. It's in the circularity of the system. So you get arrested and charged, and in most cases, you'll be brought into a police station. In some cases, you won't be, but in most cases, you will. They'll process you, they'll get your information, they may question you. You exercise the right to remain silent, which I advise you to do, and it's time for them to make a decision. They could release you right there with a promise to appear in court. And many do get released from the station. But 300% less than 25 years ago. Or they can release you with some terms. You provide some undertakings, right? So you've been arrested because you had a fight with your faculty members. You had a fight with your professor, you hit your professor with a spatula, and the undertaking is you're not going to be taking that class until this is resolved. You make an undertaking, I won't go into that class. You say, hooray, if I had known. Anyways, I'm going to have to come up with a better example. But anyways, you're released on an undertaking, and if you breach the undertaking, you get charged. Or the police say, we're going to get this person in front of a justice of the peace and have a bail hearing. And so if you've been arrested after 2 o'clock in the afternoon, you're going to spend the night in jail. You're going to jail. And you're going to be picked up at Maplehurst or Toronto South or whatever the correctional center is. And they're going to shackle you up and put you in a van, also shackled up, and take you to your local territorial or provincial court. And in Ontario, if you're in the GTA, it's going to be one of the Toronto courthouses. If London, we know, you'll go to the London Criminal Court. If you're in the 905, many of you will go to Brampton, others will go to other smaller courts. The reason why Brampton's the biggest is it's consolidated. Brampton is the busiest courthouse in the country because it's got the most traffic, and they consolidated a bunch of courts and put them into one. Toronto, for example, has 5 criminal courts. And apparently they're going to consolidate them, but I said they were going to consolidate them when I was Attorney General, and it didn't happen, so I wouldn't hold your breath. So arrest, off you go for pretrial detention, and then you get your hearing. Depending on the court and the time of day, you probably are not going to be heard right away. The only way you're going to be heard right away is if you have memorized your lawyer, you have a criminal lawyer, number one, and you've memorized their telephone number, because your phone's been taken away and you can't access it. So, in many cases, the court's only going to release you on consent with the Crown if you have what's called a surety, which is someone who's going to basically be your babysitter. They're going to be your civilian jailer, and they undertake, on penalty of thousands or thousands of dollars, to be your babysitter. So they tend to be your parents or your siblings, or in some cases actually your boss who wants you to stay on the workforce, or a friend. But that person has to take time off work and come down and show up at a certain time, and it needs to be before 2 o'clock in the afternoon, because if that doesn't happen, then the justice of the peace in many cases is going to say, I'm sorry, we're not going to have any contested hearings. So if you want to fight for your freedom, you're not going to get heard that first day. And you're probably not going to get heard that second day. And in British Columbia, you're not going to get heard until the 12th day. In Ontario, the median number of appearances is you're going to get heard the 8th day. So then when you get released, the court puts a bunch of conditions in place in order to prevent you from doing again what the court fears you're going to do, based upon a police report of what you allegedly have done but haven't been proven to have done. So even though there's supposed to be a presumption of innocence, you'll hear all the time in bail court a justice of the peace or a judge say, well, you know, you were found with a gun. I mean, you were allegedly found with a gun, but you were found with a gun. They'll say it like that. And I'll think, no, he wasn't. We don't know that. And, you know, guns are dangerous, and a lot of people are dying as a result of gun violence. So you're too dangerous to release. I'm not going to release you. So these kinds of findings, unproven findings, are accepted as fact. Okay. You say, well, we can train that out of the bench. We'll train that out of the bench. It's been tried many times. All right, you say, it's not that. It's that they have a record where they have committed an offense 6 or 7 times, and there's a concern that they're going to do it again. A bunch of shoplifting, a bunch of thefts, mischief offenses, the kind of offenses that often belong to somebody who has a mental illness or an addiction. So I think you're going to commit another crime. So because I think you're going to commit another crime, I'm not going to let you go near any Walmarts. This is a serious example. You've been caught shopping. I mean, you've been alleged to have been caught shopping in Walmart, and so you can't go to any Walmarts. So that's one of the orders. And then they provide the address of the Walmart. But the address of the Walmart's also the address of the bus stop that you go to catch the bus to go to work. But the police are waiting there for you, and they have you at the address, and they arrest you for a bail breach. You're like, no, actually, I'm innocent of this. Let me explain. Or it's a curfew. The court decides that you are too dangerous to be let out at night, so you have a curfew. Or the court decides that you have a house arrest. You can't leave your home. You're just too dangerous to leave your home. You have no criminal record in some cases, but you're too dangerous to leave your home. The kids who were charged with sexual assault at St. Mike's. Been following that story, anybody? You see, they were released on bail with a surety, and the surety had to supervise them all the time. That's the deal. They had no criminal records, but because of the allegation of these people who were innocent until proven guilty, the justice of the peace decided, no, you need to be watched all the time, because I predict you to be someone who's going to commit another crime. I predict that based upon an allegation, even though you've got no criminal record. You need to be watched all the time. So the breach happens, they're late for their curfew, something happened. I got to drive somebody to the doctors, my mom's sick. I mean, whether you believe them or not, things do happen in life such that you need to change plans. Or you're late for something. You're late for court. I missed a dentist appointment the other day. Now, I know it's different than a court date for me, it is. But for some people, Missing a date is part of their makeup. They miss stuff. They don't know what day it is. I don't mean they're psychotic and they don't know where they are. I mean they're really disorganized and life is overwhelming and they missed a court date. So I missed a dentist appointment. I did not get a criminal record as a result of that. They do. So then they get charged and now they go off the bail ladder. So the restrictions are even more severe. Now it's even harder for them to comply with their bail. And on top of that, the Justice of the Peace decides, I think you've got a drinking problem, they'll say. And so one of the orders is you are not going to, you're not allowed to consume any alcohol. If they're an alcoholic or an addict in active addiction, that's like asking me not to breathe. You can't ask an alcoholic to stop drinking. If they could stop drinking, they would have stopped drinking. It's a chronic progressive disease involving an addiction. So you're telling this person who's addicted to something that they can't take this thing. Well, in that case, Your Honor, I'll be abstinent for the entire period of it. It's just not how addiction works. And then the worst part of it, of course, is the crime prevention court that we have. It's so hard to get bail because it's so hard for the defendant to prove the negative. I know I'm in here with, and if you're in Brampton, the cuffs are on. You're innocent, but you're cuffed. And sometimes you're in leg shackles. You're not dressed for success in most cases. When you woke up in the morning and you got dressed, you didn't know you were going to get arrested. So one of my clients had F the Pigs t-shirt on. Bad day to wear the F the Pigs t-shirt. I had to stand in front of his shirt so the Justice of the Peace couldn't see him while I was trying to convince the Justice of the Peace that he respected authority. True story. Anyways, you're there under the worst of circumstances in the prisoner's box. And psychologically, understandably, the Justice of the Peace is sitting up there thinking, oh boy, these allegations, oh boy, I need to make a ruling here and restrict his liberty because this person looks like they're going to commit another crime. Now, where else in our justice system, in our legal system, could this be possible? Where you get jailed because of a fear of what you may do, as opposed to being found beyond a reasonable doubt that the evidence satisfies the facts and complies with the law such that you are guilty. No. In this case, we're going to put you in the bucket because we're afraid. That's it. We're afraid. We're a risk management court. You search up risk within 5 management and bail, same paragraph in Can Lee, you'll get 200 cases, reported cases, where the Justices of the Peace and the judges talk about the risk management exercise that Justices of the Peace and bail judges have to undertake. It's risk management. And if you fail the risk management test, you're going to go into the bucket. If you pass it, you're going to get out, but then there's going to be risk management conditions put on it, many of which you're set up to fail at. I mean, not intentionally set up to fail, but in some cases, it happens pretty quickly, and the defendant forgets, I've got to, I'm supposed to go to a wedding in Dakota, and then has to decide whether or not to breach bail or miss their sibling's wedding, because going back and getting their bail changed is a big deal. And the insanity arises for this reason. If the bail applicant was so dangerous, why are we letting him out after a week? Why are we letting him out after a month? He's the same, he or she's the same person as they were for the remand, except now they've been found guilty. There are people who, under algorithms, would be found to be a certain risk. And of course, the software is already being used by some police departments and are already being used by some bail courts. Not in Canada yet, but in the United States. There are people who are going to meet the profile such that, often it'll be racial considerations. We're going to meet a profile and, the red light will come on. They look dangerous on paper or by way of a program. But there's no basis to keep them in prison longer. Karla Homolka did her time, 12 years. At the time that she was released, I was the Attorney General, and many people thought she was very dangerous. But despite efforts of the Ministry of the Attorney General to get a recognizance order to restrict her liberty, akin to a bail order, ultimately the ministry failed. Because the Quebec Court of Appeal said, when you do your time, you're done. You're done. I mean, she did her entire time. You want an early release, there may be some supervision. But if you do your full time, you're done. We can't lock you up because we think you're dangerous. But that's exactly what we do in bail court. We lock people up because we think they're dangerous. But they're so not dangerous, I would submit, that they're out in a week or a month. Moreover, as you can imagine, a lot of people get practical fast in prison, right? They say, wait a minute, let me get this straight. I'm going to be here, I'm in British Columbia, I'm going to be in here for 10 days. Or I could plead guilty and I get out today. What do you think they're going to do? And then when they end up back, if they end up back in the criminal justice system, they have a conviction on their record, which is going to make it very, very, very difficult for them to ever be released. And almost impossible to get a job. And this is the insanity of the system, and this is where it feeds itself. Because the #1 crime in Canada is bail breaches. Bail breaches is what's filling up our system. Bail was supposed to be about this, about stopping fugitives. In that movie, the Harrison Ford character, after he's been arrested, flees the jurisdiction. That's what bail used to be for. And then at some point, it became, because you couldn't prove that Dr. Kimball was going to flee the scene. Actually, that's not what happened in his case. I think that he escaped the police station, but that's a whole other story. Bail, historically, was about stopping people from fleeing the scene. In circumstances, ancient circumstances, where the distance between individuals and the courthouse was substantial. Right? It would take days for them to get from where they were to the courthouse, and there was a risk that you don't keep them here, they're never going to end up back here. Now that creates a whole other issue for the remote regions in the north. But the way that plays out is that Indigenous people, primarily, get locked up. The argument being that they're a flight risk, when in fact all that is the case is that they're Indigenous, that's why they're being locked up. Okay, you say, you get rid of bail, come on, what about the flight risks? What about Harrison Ford? Well, technology being what it is, we can track people. So again, because we aren't talking about the most dangerous cats on the planet, if they miss their trial, they'll be able to find them. And right now, the technology is very rudimentary because the only people who can afford the bracelets are rich people. So rich people will pay for the bracelet and the tracking and the monitoring. They get to use the bracelet with their private counsel paid for. Everyone else goes to jail instead of getting to wear the bracelet. So I'd argue the technology is only going to get more and more and more and more advanced. And we may have a circumstance where even, because this is where it gets the toughest around violence against women, where if the person wearing the bracelet was needed to be monitored, you could have a technology such that if the person was within 5 miles of where they weren't supposed to be, that could be tracked. 911 called, and for all I know, the the bracelet could have its own deterrent within it. Okay, what about the exceptions? And this is a serial killer. What about the exceptions? Really, you're going to release a serial killer after you've caught him? Well, the only exceptions arise in the context of an evinced flight risk. You have evidence of a flight risk rather than a speculative crime risk unconnected to the underlying charge. Well, then they're held. And there are such cases, but I think they make up 2.5% of the system. It's the only legitimate purpose for bail. The reason I say we scrap it is because we've been trying. If you're really interested in this issue, please read Professor Friedland's Bail Reform Act Revisited, where he talks about his seminal work in 1965, where he kind of exposed the bail system. And at the time, John Turner, the Justice Minister, and the Prime Minister, Pierre Elliott Trudeau, changed the Bail Act. And you had a just system for a very short period of time, after which it got reformed and the statute created all these other exceptions and the system started to feed itself. CCLA has something online with a lot of the social science and the stats. John Howard Society of Ontario has a great report. The Attorney General of Ontario about a year ago issued a directive that went farther than anything to try and correct the system. Within a year of the Supreme Court of Canada handing down a decision called Antic, which was their way of throwing down the hammer of Thor to stop the bail practices continuing as they were, and no impact. And I was able to see it on the ground because I was there in the bail courts. I could see what the Crowns were doing in response to the bail directive. There was a bail experts table recommendations with all the gurus who participated, and they made recommendations. And the point that Freeland made was he goes back to bail court in 2012, having done his study in 1965. And he says basically the same court as I saw last time, including the part where there's 0 computers in there. It's all done on paper. He said nothing's changed. And it hasn't, and it won't. Primarily because of fear, because of public fear. If you create a test that says, that allows people to be risk averse, they're going to be risk averse. So the pros and cons, I'm not going to read them out to you, but there they are. If CCLA can, through a series of litigation, make bail too expensive for the system, in the same way as over-incarceration became too expensive for the states in the United States, then you may get a government changing it a little bit. But this is going to have to be done through a series of, through the jurisprudence. If you were ever going to get a federal government interested in real bail reform, or a provincial government interested in real bail reform, we had it. We just had it. We had it when I was there and my successors were there. We have it in the form of the current Prime Minister and Justice Minister. And it's not going to happen. Politicians are not going to do this. And you could say, oh, that's terrible, and it is terrible. But that's the way it is. Lastly, this is the biggest risk right here, is the fear of the unknown and the actual impact upon women and children. We don't know. Now, because we don't know, we keep people locked up who are innocent. If we knew that there was going to be an increase in harm to women, because when we talk about domestic violence, it's not just women, but it's predominantly women. So there we go, those are the pros and cons. Lastly, we could start by addressing this proposal and abolishing bail for Indigenous people. We make up a quarter of the prison population. A quarter of the prison population, 9 times their representativeness in the general population. Prime Minister talks a lot about reconciliation, but continues to preside over an administration that is not reconciling if they are incarcerating Indigenous people at such a rate as to show the worst systemic bias imaginable. So there's the website. I'm Bryant at ccla.org, Bryant at ccla.org. Or you can find me off the website. If you're interested, we love your help, I'd say, to faculty and all students. And I'm happy to take your questions. Thank you.